I had an email from Craig asking me to do a video on witness statements, so I thought this would be a great topic. But first of all, if you're new to me, I'm a barrister who helps you understand law, so make sure you hit the like button and subscribe if you find this video useful. So witness statements are something that a lot of people get confused with, because a lot of people, when they file their claim, don't realise that that isn't the evidence. When you file a claim, you fill out what's known as a particulars of claim. Or in a small claim, you might file it online and it just asks you for a chronology of what happened. In a full claim, you would write out a full statement of case, as it's known, which is your particulars of claim. Those are the facts upon which you rely in bringing your claim against another person, another party, or another company, and so on. When they reply, it's in the form of a defence, which is their statement of case, and it's their factual defence to the claim that you've alleged. The witness statement is different from all of that. The witness statement is your personal evidence. So, for example, sometimes people will say there's no evidence that this happened. But in fact there is, because if somebody saw it happen, they write out a witness statement in a civil case. I'll come back to criminal cases in a moment. But in a civil case, they will write out a witness statement, and that becomes their primary evidence. And in civil cases, the witness statement invariably is going to be your primary evidence, as in it will stand as your evidence in chief. Evidence in chief is your main evidence. You will be cross-examined on that, and I'll come back to that as well in just a moment. So in civil cases, you will write out a full witness statement, and it's got to be in a given format. It's got to have a proper declaration at the bottom, which you can find on the Civil Procedure Rules website. But also it's got to state the source of the knowledge of all of the facts and the evidence that you provide within that witness statement. So it will open along the lines of, I make this witness statement from matters that are within my own knowledge, and when I refer to matters that are not from my own direct knowledge, I indicate the source of that knowledge. And that might be as simple as something like, I know this because X person told me that that's what happened. Or I read it somewhere, I saw a report, or so on and so forth. All of that because if it's not your evidence, then it's hearsay evidence, because hearsay evidence is anything that is not said in oral evidence that is truth of a matter stated. So if you put something in your statement that is truth of a matter stated, but it's not your evidence, it's someone else's or a document that you've seen, you need to indicate the source of that document. And you might even be able to put that document or someone else's statement in as hearsay, even if they don't turn up in court. But it needs to be served at the same time as your witness statement. So your witness statement becomes the evidence that underpins and supports the claim that you've filed, which is contained within the particulars of claim. Now, Craig's email also asked, how binding are witness statements? i.e., can they say that I got mixed up? Which I'm going to come back to. And what if you prove a witness has lied in their statement? That kind of thing, Craig said. So let's deal with those now. Those are dealt with by way of cross-examination, because first of all, dealing with the how binding are they, well, it's as binding as the court says so. If the court believes and accepts your evidence in your witness statement, then it's binding. The court will make a finding of fact. The court will often say something along the lines of, I prefer the evidence of Craig, or whoever it might be, because their evidence is more credible. And all of that is down to the way you give evidence in the witness box, and the coherency, the consistency, whether it's backed up and supported by any other kind of facts, whether it's supported in law, and just logically and on the balance of probabilities, whether your evidence is more likely than not to be credible and to be truthful. Now, coming back to that point of, can they say I got mixed up? Well, yes, absolutely. That is precisely what cross-examination is for. For example, I've been accused by a witness that I was cross-examining in court at one point to say, it sounds like you are just telling me your side of events rather than asking me about my evidence. And I said, respectfully, that's exactly what I'm doing. That is the purpose of cross-examination. I am putting to you the opposite version of events and suggesting that you are mistaken. And I am required to put to you that you might be mistaken or misremembered about these facts to give you an opportunity to respond to it. And that is indeed what the rules say. As a barrister, as counsel, you must give a witness the opportunity to respond to the allegation that they are mixed up, that they've misremembered, or worse still, that they've lied, fabricated, exaggerated, embellished, or enhanced their evidence to support their case. And in doing so, I might reveal inconsistencies. For example, in one such case, the witness said that they were absolutely in control of the finances, nobody else had any input into those finances whatsoever, and yet when asked about a specific element of those finances, the witness couldn't answer. I put to the witness that it's inconsistent, isn't it, that you say that you had complete control of the finances, and yet you cannot answer the question upon which my client's case relies. And so that led to an inconsistency and perhaps a lack of credibility in that witness, because the two cannot be true. She cannot have had a complete control of the finances and all of the documents in front of her, remember, and not be able to point to specific items and costs and income that we're referring to in the case at hand. Long story short, that witness was not deemed to be credible by the court because she couldn't account for various things along the way. And so my client won his case. Now, it's very different to if a witness has lied in a witness statement. There's two possibilities here. The lesser of the two is simply that the court just discounts their evidence because clearly it's been fabricated. The worst case, which is very rare, but the worst case is that they can be held in contempt of court, because when you swear a statement, a witness statement, you are swearing that this is the truth to the court. So whilst technically speaking you can be held in contempt of court, which is a criminal offence and you can be imprisoned for it, it's very rare, but it does happen in situations where it is so severe and there are such lies that the court deems it necessary to punish a person for essentially lying to the court. So as a brief summary, if and when you ever file your claim, or indeed your defence to a claim or your counterclaim to a claim against you, remember that the claim, the counterclaim and the defence and the reply to the defence are merely statements of case. They are the facts upon which you rely, not even the evidence. That comes at a later point. That's usually the advocate's job in what we call a skeleton argument, or if you're representing yourself, you can research the law yourself and you can submit your law to the court when you go and represent yourself. But the witness statements stand alone. They are entirely separate from the statements of case. They need to be filed well in advance of the trial. Look out for court deadlines as to when they tell you that it's got to be filed, but it must be at least 14 days before any trial date. But remember, if the court gives you a different date for filing your witness statements, you must comply with that. Or indeed, if the court gives you permission to file them at any other time, you can do that as well. So as a standard rule of thumb, follow the court's instructions in orders and notices that it sends out. Because if you don't, you risk your evidence and or your statement of case being struck out, meaning they no longer exist, you can no longer rely on them. And if you have no evidence to underpin your claim or your defence, then your claim or your defence is likely to fail. And indeed, if your claim is struck out or your defence is struck out, then there is either no claim, meaning your claim is dismissed, or there is no defence, meaning you will get judgment against you. So it's important to follow those rules because otherwise it gets struck out. And a number of times we get clients come to us that have had their case struck out, their witness statement struck out because it was late or it didn't comply with the rules and so on and so forth. So it's important to get these things right. That's why it's important to take advice. But in small claims, typically the court will allow a little leeway, but only if you are at the very least trying to be cooperative. If you are trying to be uncooperative, then expect the court to strike you down for it, because the court wants everybody to be cooperative and to assist the court in resolving the issues. So I hope that's useful. Please hit the like button and subscribe. If you like this content, there is more, and there's going to be a lot more over on my BlackBeltBarrister website. It's a subscription service where I talk about the rules and how to comply with the rules in a lot more detail. Also chief examination, cross-examination, and general barrister skills. So check out the website. It's on screen in every single video and it's in the description in every single video. I hope you find that useful. Please hop over there and subscribe. And in the meantime, thank you for watching.